Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
Welcome to Liberty Trigger. Folks, Senator John Kennedy just exposed how weak some of these judicial nominees really are. And I've got to tell you, if these people end up on the federal bench, we're in trouble. First up, a printing shop worker shows up in a burqa. Owner says no. Employee says yes. Boom, lawsuit. Now, under Title VII, religion is protected. But here's my question. What about the rights of the business owner? See, the left loves to talk about freedom, unless it's your freedom as an employer. Then suddenly you don't matter. Patriots! If business owners lose the right to run their shops, we've already lost America. Then Kennedy asks,
If the small business owner said it's dangerous, the employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon. David
Bragdon.
Bragdon. Thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
It's going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's your name?
This is Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. Let me go back to Mr. Orso. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What What's the difference between a preliminary and a permanent injunction, and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs
Right.
after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough.
What if customers don't like it? And the nominee basically shrugs. Not a good enough reason. So now the government is telling you that the people who actually pay the bills, your customers, don't matter? Are you kidding me? When Washington tells you customers don't matter, what they're really saying is, you don't matter. And when Kennedy brings up safety, common sense, the nominee squirms again. I'd need to check the case law. Really? If clothing is a hazard around machinery, you don't need a law book. You need common sense. Patriots, common sense should come before political correctness, every single time. Then it gets worse. Kennedy asks about supplemental jurisdiction. The nominee freezes. He can't answer. Folks, it was painful. Judge Rodriguez had to step in like a substitute teacher. This is Law School 101. If you can't explain basic law, you don't belong on the bench. Period. At least one nominee remembered Article 5. 2/3 of Congress or the states. Okay, good. But here's the problem. Do they respect the Constitution? Or do they just see it as an old piece of paper to be reinterpreted whenever convenient? The left doesn't want to amend the Constitution. They want to erase it. On injunctions, Kennedy basically had to spoon-feed them. Look, preliminary is before trial. Permanent is after. This isn't rocket science. If these nominees can't explain an injunction, how can they protect your rights? And when asked about class actions, the nominees stumbled through Rule 23. Numerosity, commonality, typicality, adequate representation. It should roll right off the tongue. But nope, another shaky answer. And this, patriots, is the bigger issue. These aren't just mistakes. This is a pattern. Nominees who are weak, unprepared, and more interested in woke ideology than in defending the Constitution. They know the buzzwords, but they don't know the law. And that should terrify every American. Why this matters. Courts are the last line of defense for our freedoms. If the courts go woke, America goes broke. Simple as that. Thank God for Senator Kennedy. He's holding the line. But we need more like him. We need senators who will vote no on weak nominees. And patriots, we need you to stay engaged, because if we check out, they'll stack the courts with people who don't know the law and don't respect our freedoms. This is Liberty Trigger. Hit that like button, share this video, and subscribe, because the truth needs to be louder than their lies. God bless you, and God bless the United States of America.